And there we go. All right, cool. Let me put this on this screen and then I'll go ahead and share it. Hi, everybody. Again, today is the dependency work group. The recording is going. And share. No, not that. Go with this one. I don't think we're actually on page 56, though. Yeah, that's in the parent stuff. All right. Yeah, I think we start with hearings. Does that seem right to everybody? That's where we're starting?
On 8, yes.
Yes. Okay, cool. Then let's go ahead and move forward with that.
I am going to try, I'm going to try to use just the computer. So give me a minute. I accidentally deleted the file. I mean, shut down the file, not deleted it.
Oh, sure. Okay. So I think our first is this one. I think that's straight up the so here's the thing. Prepare for close to a must. Because I mean there are some hearings that you're just gonna get thrown into with no time to prepare, like shelters. But attend all hearings, including pretrial conferences, I would absolutely say is a must. So what do y'all think? And I absolutely know where you're going, where you're coming from with your comment too, Dawn.
I think must prepare. When I think of preparing for and attending all hearings, I get that you show up for a hearing, but preparing doesn't necessarily mean the work that you do that day or the day before for a hearing. I think of being prepared meaning you if you need a one sheet with you, so you know when things come at you randomly,
Okay.
you think about it. If a big case comes out, you read it. Also, if you put prepare, you must be prepared. You are sending the message to the courts and everyone else that when we say it's our day to do prelims, our day to do shelter hearings, we can't book up till the very last second before a shelter hearing because
Right.
we have a contractual obligation to have time and space to read the discovery and think about what we're going into here to the courtroom to deal with. That's why I think having must is important.
Okay, I feel you. Um, so just like what it means to be prepared might not be the same for every hearing, um, but we do need to ensure that you're prepared.
Well, and ideally, you know what kind of hearing you're going in.
Right.
Right. You are contracting with lawyers with the expectation that they must manage their workable hours and communicate to the courts that they need space in their calendar to be prepared for what they need lawyers to do. Otherwise, judges and other people would say, oh, just send somebody. If you don't say that they must be prepared, can't you just find somebody to show up? We want to say no, we're lawyers and we prepare for hearings, and the people we send in to do the hearings are prepared because we require that.
Okay.
I mean, you would want a way to coach and manage a lawyer. I'm not saying that any lawyers I know would do this, but think that it is okay to drive back from a trip from Seattle or wherever and literally just walk into a hearing.
Yeah.
By using the word must, you are saying This is what we need you to be prepared to do.
Okay.
Well, and I think this is probably the first time I've thought about these standards from the other side, which is that if I were the client, I would want my lawyer to be prepared. And
Right.
preparation looks like a lot of things. I mean, sometimes preparation is just that we have experience. And so we know, some argument that gets thrown at us, we've heard it before,
Right.
even if we didn't specifically research it. But yeah, I think it sends a weird message if it's the client's lawyer should prepare and must
Yeah.
attend all hearings. It sends a weird message.
Okay. All right. I feel that as a discrepancy. Okay. Then we'll use this. We'll flag this one as a must. Okay. All right. Child client's lawyer must prepare for and attend all hearings and participate in all telephone and other conferences with the court. I think that's subsumed. I don't know that that needs to be said a second separate time. But then, I mean, that's just the structure of how the OSB standards were written. Okay. I did not necessarily think we needed to explicitly state this. I don't know that we need. I don't know that we need to. I don't know that we don't need to. What do other people think about this?
Explicitly state what? That the position may overlap or?
Yeah. Like this just feels like if you know your role, then this feels like surplusage to me.
Well, as my copy indicates that I don't think we should put that in there. Again, I'm coming from the point that the bar manual is a great tool to think through what it means to do things. The standards are directions to the lawyers you are contracting with about what you expect them to do. And that's why I have stricken it.
Okay. All right. Okay. So I'm going to keep that as unhighlighted. Then some commentary. Again, I don't know that any of that's true. Whoa, that's not what I wanted. There we go. I don't know that any of this is truly necessary to reiterate.
I'm trying, okay, you're on page 40. I'm trying
40,
to
yeah.
see. Okay, before we go to 40 on the bottom of page 39, I thought that we should, I don't know if you're leaving in actions or making things part of the standard, but the child's lawyer where it says participate fully in every hearing, I think that should be a must and not, I don't know if you need to discuss or if you just want to know that that's my feedback on it, Kevin, and people can make decisions.
So I actually disagree with this for a different reason. And that is hold on. I forget what is this all came about from a case in like 2017. It's the whether a child's statements are hearsay of a party opponent. And
Yeah.
my read of the case law and the ethics rules around that is that you should never, unless it is unless it like your client specifically gives you permission to do so, you should never explain their position. I mean, and maybe that's maybe I'm saying it wrong. You can explain what their position is, but not how you arrived at it, if that makes sense.
Okay.
And like that, and maybe that's just tweaking this language a little bit, but my read is that because sometimes the question the court's going to ask is why, you can't answer the why, right?
Well, maybe we strike that and explain the child client's position part. When I think about why, if the why is what facts are you pointing to because you have that position,
Yeah.
and what is the law, then I would use the
Yeah.
law and the facts to explain where my client's position and advocate for it. But
Yeah.
if the explain is tell them why my client wants to go home with their mom, and it's because mom lets them smoke dope and lay in the house and not do their chores all day. Of course, I wouldn't explain that.
Right. Well, and I mean, for me, it's just like the why can sometimes get to the core of my assessment of my client's capacity, which is where we run into that. You know, you don't get to ask me why I've come to this position type thing. So that's where I'm a little like, is it a must? Because here there's that play with what is the boundary between this desire to, you know, I do absolutely think that there is an onus on the attorney to say, like, if we're talking about explain the position as, you know, what are the facets of the position, that's one thing. If we're asked to explain how did we arrive at that position, totally separate question, and that's what leads me to a should at best for this.
Well, I think the be prepared part should be a must, and
Yeah.
not, you should always be prepared to address the any issue you think could come. If you have reason to anticipate the issue, you should be prepared to address it. Whether you actually address it or not is another thing. So that's why I think it should be a must, and I'm fine. Strike the explain if you want to, but
Yeah. Okay. So let me see if I can put this in yellow to state. There we go.
So couldn't we make it all one kind of a thing that the child client's lawyer must prepare for and participate in, i.e. state a position, have a position, even if that position is no position kind of a thing in all hearings and other court appearances, so we don't need to have it with so many words and so much separation?
Yeah, I'm gonna put a note here to include this language. That what it means to be prepared for and attending all hearings is being prepared also to state a position.
And sorry, I've been using the chat a bit because I have a
Oh, that's what I'm missing. That's what's coming.
hanger-on
Okay.
at the moment.
No worries. Let me move that over to a different screen so I can see it. Okay, cool. Sorry about that. There we go. Okay, cool. I got it now. All right. Okay, I think we're good to move on to page 40. Hearing no objections. All right. Wait, this doesn't look like page 40. That is still 39. All right. I considered all of this to be surplusage. Oops. It looks like, Dawn, you thought the last sentence was necessary. Child client's lawyer should seek out training in trial skills and watch other trials to learn from them.
now that you read it out loud to me, that might be incorporated somehow in the qualification section or something like that.
Yeah.
This
Yeah.
is under should.
I would say at best this is a should. It's not a must, but we can. I'll code it blue at the very least, and then goal is we'll have a draft that we can come back and review offline to put comments and things in as well. Okay. If the court proceeds in the absence of the child client's lawyer, the lawyer should consider filing a motion to set aside.
I said it should be a standard, and the should remain should. You should consider it and make a decision. Or
Yeah.
I mean, must think it through. I mean, I'm assuming, but must, should.
Yeah. It doesn't, I wouldn't say must, because there are hearings where my participation as the child's attorney means, little to nothing.
Oh, well, the must consider, must think it through.
Mhm.
That's what I'm saying, not
Must
that you
think
must
about it.
file it. I think it would be hard pressed to require us to file anything.
I've agreed.
Right. Yeah.
Agreed. I just for like maybe it's just like a linguistic issue, but I have a telling people what they have to think seems weird to me. So telling somebody that they must consider this is weird. A should feels more appropriate to me.
How
Uh,
often does the court actually proceed without the child's attorney? Because
All the time.
yeah.
really,
Yep.
Yep.
They don't have time to wait.
that does not happen in my county. That's nonsense.
I would say that does do you really need to be here?
Mm.
Can we start
is-
without you? Can
which
we
is
start without you? And you
one of
can
the
come
reasons-
after that Heather hearing? We
Well,
get
one
that.
of the reasons one of the reasons I like keeping the must be prepared language in is because if I show up to court and DHS hasn't filed whatever they need to file, I'm going to tell the court I need time to go review all of this.
Mhm.
Like
It's an obligation.
Just had the judge today, a referee today, when I did not get the report, and my client is very involved but lives on the East Coast. And I said, well, I just need maybe a short set over to forward this to her and let her look at it, get her feedback because she provides it. And the judge says, well, we can't set over this here. And I'm like,
We have time.
I said, you can set it over since the statute says this. Oh, we can't set it over because then we'll have a CRB. And I'm like, you can, because the statute says that my client's entitled to this 3 days in advance. But anyway, I digress. Sorry.
I mean, yeah. Okay. All right. Any changes to this one? Wait, let me see. Can I make it bigger for y'all? There. Is that helpful?
Thank you.
No worries. One more step. Yeah, that's
Great.
big enough. All right.
I would.
Okay.
Okay, when you're talking about any changes that action, is it possible to make that a standalone standard, or are you going to have actions under the bold?
So, I hold on. So the way I have this, I would be putting this as one of the bold. Like in general, blue for me is the stuff that's not bolded. The yellow is the stuff that is like the bold standards.
Okay,
like these
got
are
it.
the and I think not all of those bold standards are necessarily always going to be musts. Because I think there are things we need people to do, but yeah, anyway. So, okay. All right. Commentary to that. The child client's lawyer has a conflict with another courtroom appearance. Child client's lawyer should notify the court and other parties and request a short continuance. Should avoid having another lawyer stand in. I don't know that we need this to be explicitly said. Okay. I'm seeing a lot of shaking heads. All right. Child client's lawyer should request the opportunity to make opening statements and closing arguments.
So this is under the category of hearings.
Mhm.
And hearings include a lot of things. And I almost never think it's helpful to make an opening statement in a review hearing.
Well, not just that, but if we're talking about hearsay and you represent a child client, if you make an opening statement and you express a position either with the state or with the parent, then you get that party opponent hearsay stuff coming in. And so it's almost better as a child's attorney not to make an opening statement at all. So that they can't come back and say that.
Oh,
Yeah.
good point. What about changing it to
depends.
say the lawyer should strategize around making opening and statements and opening statements and closing arguments at appropriate hearings to achieve the client's goals?
I
The
think
requirement is you have to think about it and have a strategy.
I kind of agree. Should maybe consider whether to make an opening statement and closing argument and request it when necessary. Because I also agree there are times when opening statements are not a thing that you would necessarily want to do, and there are times when it is something you would want to do. I do think I I I hear where you're coming from, Jen, but I'm not necessarily on board with the hide the ball uh play. Because I think to a degree you do have, like, if the court asks you what your position is, I think you have an obligation to respond as to what that is. And
Of
I'm
course, but
also
that's not an opening statement.
no, I hear you.
Like,
But
if we're talking just standing up there and going, Your Honor, this
Yep.
contested jurisdiction, my client wants this. And then your client's locked into whether or not that happens as things
Yeah.
progress at trial, them being called as witnesses. Like, I don't know. It just feels like it needs to be a strategic decision that the lawyer needs to make, not that they should do that every single time.
I true.
And then
And
I'm going to request everyone's positions at the beginning of every hearing.
yeah.
Well, I was just going to say, some of the attorneys in our office are taking to filing motions regarding clarification of positions
Yep.
so they're prepared.
I mean, I think that's a solid litigation strategy. I mean, knowing where everybody stands is probably a huge, I mean, how do you know whether you can enter hearsay
Yep.
unless you know where everybody stands? Um, the I do think that opening statements and closing arguments are not on the same footing, and I think it is a much stronger, you should be making closing arguments in every case.
Yeah.
Um, I don't know that that's necessarily a must, but I feel like it's pretty close. I don't know of many, and part of that is like and it's part of the what the OSB has in the commentary here, is that there's a long history of attorneys for children acting as neutral arbiters and telling the court, here's what I think should happen. And I think we need to push more that that is not the direction that we go. We have we have clients, they have positions. At the end of the hearing, we take a stand and say, this is what my client wants, and this is how the court gets there.
Yes, with the caveat that we also have babies and infants who can't articulate a position. So that we do sometimes end up in more of that, like, based on what I've heard today, if that turns out to be true, I think XYZ should happen. If you get what I'm saying?
I do, but I disagree with you. I think that the duty is to have that just like get all that information. Like, part of what's up earlier is the investigation piece, and I think that's a culture shift. There's a lot more investigation that I think is necessary in cases that people aren't necessarily doing because they fall into that. And I think you should have a position at the start of the hearing. And maybe something comes up during the middle of the hearing and you learn more facts and that changes what you think your client's position is. But the fact that they can't articulate it doesn't mean that they don't have one. And your job is to figure out before the hearing what it is so that you can advocate for it at the end of the hearing.
Well, of course. I think that falls under the investigation part. I think that falls under the being prepared to articulate a position part. But I don't think that as a child's attorney, I need to stand up in a permanency hearing and say, Your Honor, I request to make an opening statement. My child client feels this way. And then the closing statement go, well, based on the new UA that mom provided, if she continues to be clean, then we'll ask for more visitation time. Like, it would make sense to include that all at the end. Like, it just feels more like a strategic decision on a case-by-case basis, not something that we can advocate that they do every single case.
Sorry, go ahead.
Oh, I was going to say, my thoughts were that the standard should be a must, that you must think about it and have a strategy in regards to what you're going to do.
Okay. closing arguments. Okay. I don't know that you need to request the opportunity to make them. That kind of falls into it. Okay. All right. Blue area, child client's lawyer should make opening statements and closing arguments to frame the issues around child client's lawyer's theory of the case and to ensure judge understands the issues. Again, I think that's explanatory of what's already bolded. I don't know that we need to necessarily have that. What does everybody else think? Like, is this a separate enough piece? We could go the other way too, where B is like this bolded stuff is actually, we won't include that. We'll just include the other piece because it's more explanatory.
I think that's what my comment said on in my yellow highlight was make that be. And I said it should remain should, but I think what we've come to the consensus on is we must think about it and have a strategy regarding it. And then either you.
I will just say I do like Jen's language in the chat around this one.
And I'm going back and forth between, I wish I had 3 screens at this point. Child client should be strategic in determining when to request. Okay, yeah, I like that.
For some reason, let me see if I can get the chat up. I don't have my chat up.
Yeah, I'm trying to. No, you're good.
There we go. I got chat up.
I'm trying to juggle what we've got on the main screen that we're all looking at, and then the chat and Dawn's notes on only 2 screens. I miss having 3.
Well, I can relinquish the response that you can relinquish the responsibility of mine because I've got mine up on my second screen, and I'll tell you what is if that's helpful. If that's helpful, it gives you more screen space.
I think we're good. Okay. All right.
As long as I know what page we're on.
I'm gonna steal your language, Jen, and I'm gonna put that in whole cloth.
Please do. It's what I paid so much money to go to law school to learn how to do.
All right. Do we think any of the other commentary on this page is some? Dawn, you've got it all stricken through, so I'm assuming no. I think that's just kind of the explanation of the history and why they want this thing to exist. So I'm not super in favor of keeping it. All right. Child client's lawyer should prepare and make all appropriate motions and evidentiary objections. Must be aware of the need to make a record for appeal.
That's a big one. I might also, the idea of creating a record for appeal, I think a lot of attorneys lose sight of that quite often. Like, you know the judge is going to disagree with you because this particular judge feels this particular way, and so you don't want to piss them off, and so you have this urge to not say it. But like, if you need to throw the things at the wall, throw the things at the wall so it's there on the record for the appeal. That might need to be a separate one. And then as far as the make all appropriate motions and evidentiary objections, I think that needs to be framed within the client's theory of the case.
Well, I think by saying make all appropriate, that I was acting on the assumption it is consistent with your client's goals and theory of the case. And I think that should be, again, must, for all the reasons I have said must before. You want your lawyers that you contract with to know that's an expectation.
Yeah, although if I fail to make an appropriate, objection, am I screwed?
That's exactly what my thought was, which is if we make that a must, are we setting the bar like to a degree to a height that is difficult for even experienced to turn, like the most experience. Like, I don't catch every evidentiary objection. I'm never going to be able to catch every evidentiary objection, and having a must here saying we have to make all appropriate evidentiary objections, that is oof.
What about you must prepare and aspire to make all appropriate?
Oh, wait, Jen's typing. It's coming.
You want to.
Talk about setting the bar too high, guys.
For the timing, I think having the must benefits everyone. The Office of Public Defense Services, or PDC,
Oh, easy, yeah.
the lawyers that you contract with, the clients, and everybody that's involved in ensuring that there are resources, including bandwidth, to be a competent lawyer.
Okay,
So-
how about that? The child client's lawyer must be prepared to make all appropriate motions and evidentiary objections.
I mean, it is there that it's a child must prepare. I see. So we're changing the
Prepare
language
to make.
prepared.
So it's not
Look at the
holding
chat.
you to the
I
ones
like
that
that.
you do make, but saying that
Yeah.
you need to be prepared to make them, i.e. you need to review the evidentiary objections.
You need to have the
Go
training.
through your
Yeah.
facts, figure out if they're going to offer just a report or if they're going to have the actual person there, that kind of thing.
Okay.
I mean, one of the things I worry about this is who's defining appropriate and how does that blow back? And part of the reason is that I had a particular case where OPDC appellate said you should have filed a motion to dismiss. You need to do that. We staffed it. I did not. They accused me of ineffective assistance of counsel. It was AWOT. But what happened is that I had to get off a client I'd represented as a teenager and a parent for 5 years. And like she fell apart. And so I'm just very concerned about how are you defining this and what happens as a result. Must makes me really nervous in this regard. And that's probably just because of my own experience. But
Well, no, and that has a lot of, that really resonates, right? I mean, we are working for children. We are working for people who have long relationships. We are working for people that are yes people sometimes. So the new attorney says, hey, we could do this. And they're not able to process all really process it through. And everybody's doing the best they can to be the most competent lawyer they can be at their stage. Is there a way we could word this that sends the message that the expectation is that you prepare for and do the best you can to make informed, thoughtful decisions and objections as it comes at you? Trial
think it's the
level,
should.
like,
I think that's. Go ahead.
I don't like the
speak a
should
little
about the
bit.
preparing, because the story we just got, that experience was a prepared lawyer. That like covers the must be prepared. She was absolutely prepared. Another lawyer just happened to disagree in the strategic pieces of it. So it is being able to, I think I strongly advocate for a must prepare and should, I don't know, given, and then somehow should do the best you can given the information you have in a live courtroom under fire.
So what about the child client's lawyer must be prepared to make motions and evidentiary objections consistent with client's objectives and trial strategy? That gives that discretionary piece to it of like, this is my trial strategy, this is my client's objective, this is how I'm choosing to handle it, and reasonable minds can differ about that.
And I'm doing it under fire.
Yeah.
yeah,
On the battlefield.
Yeah.
when you're looking at the judge's face and you're like, how far do I go?
And your client's shoving you the notes about things that have nothing to do, and you need that person to feel heard and respected.
You stand up and the judge just sighs again.
And the judge says, that is a lucid, intelligent, well thought out objection. Overruled.
One of my favorite courtroom moments is arguing with a referee at a shelter hearing. And then she looked at me and she said, well, Miss Stoller, rehear me then. My client said, I don't actually care about that issue. I was like, ugh.
So that's my favorite.
Okay, so moving on, I think this next one is actually just a restatement. I don't think we need. I mean, it kind of just gets the extra part that we put in over here, gets that into there. So I think we've got it.
Okay.
File member. I do think that we should keep the blue part as a best practice. Filing memoranda and points of authorities. I mean, hell, if I could do a trial memorandum ahead of a jurisdictional trial, if I thought it would be helpful, I don't know that I've ever had time to do that.
Time or having a complete witness list of who everybody's going to call and who's going to show up there, like that's counting your chickens before they hatch, my friend.
Right?
Are you suggesting we're going to have like practice tips? I mean, I think it's.
I mean, we do.
If you're including practice tips, that's fine.
Yeah.
And support it when you can. When
I know.
Yeah.
when it's
to.
strategically appropriate.
Yeah. I mean, I do think there are a lot of, for a lot of the motions, we have to do points and authorities and memoranda to support them anyway. So I don't know that no, sorry, little dog trying to get it. Just a sec. She's not going to stop. I'll be right back.
I think, I don't know that we need the second sentence there, which is the child client's lawyer should always be aware of preserving legal issues for appeal, because we get that in the other.
Well,
lawyer
but
must
I'm
be aware of
wondering,
record for appeal.
although I'm wondering if the sentence that says the child client's lawyer must be.
Sorry, I'm trying to see. Does it? Did we have the appeal thing already said somewhere?
Yeah,
Right. You went by it. I was reading
did?
it.
It was the second sentence when we talked about separating those two things.
Oh, yeah. Okay.
Yeah.
Okay. Like, where is it? Oh.
Because I
Really
feel like
close.
you can combine the aware of the need to make a record and preserving legal. I feel like, there's a way to say both of those things.
Yeah.
Because sure, you can make a record, but you could fail to preserve everything.
Of the need to make a record for appeal to preserve the legal issues.
Yep.
Yeah.
Lots of preservation issues on. Sorry, go ahead.
Okay, I just want to make sure I know what we're talking about on the page. I'm like, it's jumping around.
Yeah, sorry, right here. This is where we're at.
You're still the blue and C. Okay, perfect.
Yep. Sorry, I was trying to find the other reference to make an appeal and realized that it was actually just part of the other thing we were talking about. Or actually, Kelsey, I think, is the one who reminded me. All right. Anybody think that we need any part of I guess yes, we can get rid of I can redo this without that, since we already we don't want it in yellow, we want it in blue. There. All right.
I mean, these standards are really such a great new lawyer training on being a child's attorney. And so I think sometimes I look at them and I'm like, well, duh. And I'm just trying to remind myself of that.
In regards to the commentary, my note was, could we make the first sentence, could we incorporate that into standard C? It's essential that the trial's lawyer understand the applicable rules, and then strike the rest of it. I'm rereading it, and it is essential. You have to take a test, don't you? I mean, it's like, wait a minute, that's the ethics test, separate exam for the bar. Maybe strike it all, but I thought it should be maybe a separate standard that you understand the applicable rules of evidence in all court rules and procedures.
I think we have a standard in the training area that requires you to have an understanding of these things, and that it doesn't feel like it's the right fit for this location to me.
All right, sold.
All right.
Yeah, no. And also, when you get into court rules and procedures, you get all kinds of like weird things that kick back motions when you try to file them, and
my
then you have to
gosh, yeah.
correct the one comma or the
Yep.
thing that, like. So I think holding us accountable for all of that and getting it all right all the time feels like we're setting the bar too high.
Yeah. Okay. Child client testifies. Child client's lawyer should ensure that the questions to the child client are phrased in an age and culturally appropriate manner.
How do we do that?
Yeah, it's a real good question.
Because you can't.
I don't know.
Good point.
Objection, Your Honor. That is not a culturally appropriate question.
Well, and
That-
also it might be strategic. Like it, like I will say, I might have been tired. I was thinking of it's like I'm helping someone have my client testify because my client wants to testify, right? So I'm like saying, okay, we need to set an appointment where you're going to think through the questions and you're going to get to know my client before you call him as a witness. If he wants to testify and if you're going to ask him questions, you should have a conversation with him before court.
Mhm.
I'm going to ask him some questions, but and I
And
was thinking,
I've absolutely done that when I'm aligned with the state. You know, I've had clients come to the courthouse, we see the court, you know, all of those things. We talk about what, you know, prep. But depending on who's calling my client or who's then cross-examination.
if the
That's
questions
where
are
my thought
crappy,
is.
it might be helpful,
Yeah.
That.
right?
I mean, I might not want to help an opposing counsel cross-examine my client, right? And I think, Dawn, to your point, it's about the pre-hearing preparation of the client and the people who are aligned with you more than during a hearing. And I think I'm going to remove the
Maybe or modify it to be some statement about if the child client testifies, the lawyer for the child should strategically somehow should develop a strategy and be prepared to execute the strategy regarding of how the testimony would be helpful.
Does this need to be like simplified into like if you represent the child client and they're going to be called to testify, like you better do something to help prepare them?
Well, and I think
Okay.
we have some of that in the preparation. If I'm not mistaken, there's a preparation. It's like standard 7, I want to say, is preparation for hearings
Okay.
that you
Yeah,
get
because
through.
this makes me feel like what I'm going to
Yeah, court
object to the
preparation.
way another
Because you
attorney
can't like
is questioning my client. That's
That'd be
not
fun.
culturally appropriate.
Right.
Objection.
Objection.
Argumentative. You are dissing my client's culture.
yeah, I think you're right. I mean, I think if it's bad enough, you can object if you have a legal basis to object to what somebody else is doing, but preparing in advance covers it.
Yeah.
Yeah.
All right.
Yeah.
Where did my cursor go? There it is. All right. Well, okay. The action associated child client's lawyer should take into consideration the law and research regarding testimony, memory, suggestibility in developing questions. Like, I do think this would be applicable to your own like examination of your client, but I think the preparation area gets at what we're really dealing with there. All right. Child client's lawyer should present and cross-examine witnesses and prepare and offer exhibits. I think this is a should only because there are times where you will not want to do that for strategic reasons.
I said make it a must, but add the phrase when necessary to advance the child client's position.
I like
So
that.
it should be must, but it should only be done when necessary to advance the position.
Yeah, but also you don't need to duplicate work. So if mom and your client are aligned, and mom's already subpoenaed the 3 witnesses that you were
No,
thinking
you
of.
you
Like, you don't have to,
absolutely need to subpoena them as well.
but I mean,
That and that is part of the court preparation, is that don't rely on other parties to subpoena their own client or their own witnesses.
Yeah.
Um,
What I was getting at is the notes and the like going in and interviewing all of those people if you're doing it together. Does that make sense?
Yeah.
Right.
Yeah.
So the
that-
when necessary to advance, I think covers.
It's like being collaborative with other parties
Yeah.
when you align. Yes.
Yeah, like there's no reason to call a witness in to 2 separate places to talk about the same thing when you're all the same side. So I guess I'm trying to think about it from the witness's perspective, which I don't necessarily need.
Oh, I'm taking this just from the in hearing portion, right? So if the you should make sure that you have witnesses that the witnesses you want to testify are going to be there, even if somebody else is, excuse me, has subpoenaed them. You're like, because I mean, there's certainly been times when DOJ subpoenaed somebody and then in like 15 minutes into the hearing they released the person from their subpoena. I'm like, but I wanted to call them.
That's true. That's true.
So, like, yeah, I'm definitely not relying on other parties to subpoena witnesses I want. But then I do think, like, to present the witnesses, if somebody calls them, there's nothing saying that you have to call again the same witness. You could do your direct examination during somebody else's. I mean, just like the court has to be aware, all right, I'm directing this, like, I'm not cross-examining, I'm directing because I'm aligned with whoever called this person or however we want to deal with it. But I'd also like, if there are exhibits that I want to offer, I'm also going to make sure that I have them prepared too. Because I didn't do that once and I got called out on it. I tried to offer one of the DOJ's exhibits. That did not go over well in court.
What? They let me do that all the time.
Ooh. I mean, it was during a TPR trial, so I think.
Okay, maybe then, yeah.
I
maybe.
think they were like, no. All right. Child client's lawyer must be able to effectively present witnesses to advance the child client's position, must be prepared in advance, and the child client's lawyer should know what evidence will be presented through witnesses, be skilled at cross-examining, should know how to. I'm actually thinking that this is, again, well, how much of this do we want to be explicitly stated?
Well, my note was incorporate this into the standard.
Yeah.
For what that's worth. Because I hear it's like good advice,
Yeah.
and the hiring and the qualifications about how skilled a brand new lawyer right out of law school is not going to be that skilled at cross-examining opposing parties. That's a training kind of thing.
Mhm.
But that the lawyer needs to prepare witnesses that they intend to call. Maybe that, like, you don't cold call witnesses should be a standard. If possible, you don't cold call witnesses.
If possible, it's a good one.
I do think the one piece that is straightforward is you do have to know how to offer documents, photos, physical objects, and records into evidence. I wonder how
What do you
much
mean?
of
You
this.
can learn that on the fly, right?
Uh,
Kevin watched me my first time trying to
oh,
do
I'm
it.
not thinking of you. I'm not thinking of you in any. But you
Oh,
might
come
be
on, in front
thinking
of
of who
Judge
I am
Marshall?
thinking of. I think it might be covered in the training section. If it's not, then I think it makes sense to keep it here. But I mean, it's just such a core
Yeah.
thing. You've got to know how to get evidence into the record. Okay. At each hearing, child client's lawyer should advocate for the child client's goals, keeping in mind the case theory. I think that's a must.
Yeah, but don't we
My
already
note
have
was I
that?
thought it was a repeat.
Yeah?
Yeah,
And maybe I went back and looked and
we have
to
that you
double
have to
check.
be prepared to participate in and voice a position, which is exactly what that's saying.
Under
It was like the
Is-
first one we went over today.
So the first one is should prepare and attend, including pretrial conferences. And then
The child client's lawyer must prepare for and participate in all hearings and other court appearances. Was
right.
what I had.
I
thought
feel
of.
like this further defines what participate means. You got to have a goal and you got to advocate for it. But I'm cool with pulling it out as well if we think that it's too repetitive.
I thought it was repetitive, but if you feel like the point of when you participate, you need to do it with a goal and a theory in mind, we could add that phrase to the standard that talks about participating.
Yeah, because I think with all of this, we could add in the consistent with client's objectives and trial strategy kind of language.
Okay. All right. I will see if I can massage some of that language moving forward. Okay. We have F left, and then our time is basically up, so that will probably be a good place to stop. All right, child client's lawyer should ensure that findings of fact, delete that. Findings of fact, conclusions, law, and orders that benefit the child client are included in the court's decision. I mean, I feel like that's a must.
Well, do you have a magic recipe for making sure that the judge will actually put it in there? Because I don't. I don't think we can control what's included in the court's decision.
Oh, fair
Yeah,
enough.
I do
point.
have an issue with that language. That language is confusing.
It's the
But-
ensure that's the problem.
Maybe
Well-
say must request.
Or must advocate.
Yeah,
Must advocate
for findings of fact, conclusions of law, and orders that benefit the child client to be included in the court's decision.
Yeah, it should
Yeah.
be must and advocate. Good job.
That makes much more sense.
Yes.
No, Judge, my job is to make sure that you put this in.
I will edit. Let me edit this for you.
I mean, to a certain degree, some of this may just end up being like preservation, right? Like if the order doesn't include those things, make sure that you have preserved that failure for appeal, and then you can. I mean, I honestly don't know what is the line that the Court of Appeals uses to determine whether you are like appealing something you won. But if they're not putting in the order that you wanted, I think you can still say, "Hey, Court of Appeals, the court should have done this." I mean, maybe it's gonna get, AWOP'd because it's totally within the court's discretion, but at least you're preserving it. Just cut it off there. All right. Okay. Child client's lawyer should advocate for appropriate services and request the court state its expectations of all parties. I mean, that feels like specific enough that I kind of want to keep it in as a best practice.
I
It's
said
not
make it part of the standard F. But
sorry, all of the notes are like covering each other over in your draft, so I'm having trouble figuring out which note goes where.
oh, I noticed that too. So on F where the section you just read, the child client's lawyer should advocate. My note was include this in standard F statement. So make it part of the standard. You must do what Jennifer said. Advocate that findings are and you should advocate for appropriate services and
All right. Child client's lawyer must be familiar with the standard forms and ensure they are completed correctly and that findings beneficial to the child client are included. I mean, I'm lucky if I get to see the DOJ's form proposed order for more than about 3 seconds before they hand it to the judge in person. Which, of course, because it was in open court, They don't have to wait 3 days.
I took that to mean
Such a
after it was,
silly
I thought,
rule.
I took that to mean at any time, like I've had cases where I heard something and the order comes, it's signed, and I feel like I must review the order to make sure it said what was in court, and if it didn't, file a motion to amend because it was a Scrivener's error and let somebody else say it wasn't.
Okay.
That's
And
the way I think of it.
Section 9 is the post-hearing stuff. So this
Oh,
may
I'm
be
sorry.
covered under, you're right. This may be covered under there. It might be duplicative in just in 2 different related places. So I will check that. And if it's not, we'll keep it here. If it is, then we'll just leave it in the post-judgment stuff.
No, I'm sorry. I thought you had moved to that section. I'm dividing my eyes to 2 different screens, so I should look where you're
Gotcha.
typing before I look at mine.
No, you're good. And then child client's lawyers should consider preparing proposed findings of fact and conclusions of law, frame the issue, case, and ruling for the judge. I mean, for certain types of hearings, sure, when you're given the opportunity to do written closing. I mean, I don't know that I would be able to, that this would frequently be an opportunity for like a visitation motion.
I said strike that. I was thinking of live action hearings and not where I'm filing a motion in my own proposed order.
So
But that might have been my mistake.
Well, and I've asked to do, and I don't know that there's ever been real problem with it, to do written closings for like complicated jurisdictionals or TPRs where it really is like you want to have here's what I think the court should find type thing. I don't know. I like it the way it's said should consider preparing them.
Mm-hmm.
I mean, if you know ahead of time what the likeliest findings of facts would be, you can potentially prepare some of those ahead of time. It's a lot of crystal ball work, but
So a lot of the stuff that we've just gone over is talking about what we need to do to advocate for our clients, especially in a setting. So thoughts on having that be something like the child client's lawyer must prepare for and participate in all hearings and other court appearances, and then that participation must include, and then doing subcategories for each of these things, like preparing your client for testifying, preparing to call their own witnesses and exhibits, make motions and evidentiary objections consistent with the client's objectives and trial strategy, make closing arguments that advocate for findings of fact, conclusions of law, and orders consistent with the client's objectives to be included in the court's decision. That makes it feel more cohesive of like, this is what you need to do to advocate for your client.
So like, so let me pull us back up to A. Oops, too far.
I don't know if anyone else thinks that way, but that's just the way that my brain works. I'm like, if I put it all together.
Nope, that's pre-petition. That's not where not investigation. Oh my goodness, my mouse wheel is just not being good today. Okay, 38. I think we're on 39 is where we want to be. Why is this? Where are we? There we go. Okay. So consider a bullet point list of what prepare and
participate.
Yeah.
I included something in the chat in case that helps for your notes.
Yeah. Oh, brilliant. Let me copy that over.
Jen, it has felt, I think partially because we've been cutting out so much, it has felt choppy and disconnected to me. And that pulls a lot of things together.
Okay.
I think once we get through, like, yeah, these should be standards, this stuff shouldn't be, and we look at that document, form and fluidity would be the next stage, and I love that suggestion.
Okay. I think that is a good stopping point for us. Oh, I guess there was one like commentary thing, but I don't think anybody cares much about it. Where was it? It's earlier than this. There we go.
It's-
Framing the issue for the judge. I don't think we have any need to put this in there. All right, cool. Okay, I think we're going to call it then. Thanks, everybody. I am still going to try and get a full draft, as full as I can, for the next session. So here's my thought. We just put out the criminal standards last week. Next month, we are going to put out the delinquency standards. And then I think the dependency standards are the month following that. So that's, what is it? September would be delinquency. So we're looking at October would be the time frame that we're looking. So we probably can put another session or possibly two after what we currently have scheduled in order to keep working on this. So my thought is let's try and do 1 through 4 of parent. If we can get notes and commentary on 1 through 4 of the parent side for next session, which is at 4 instead of 4:45 or 5, then I think we're fast approaching being done with all this. And I will put out again, what would be immensely helpful is if everybody's got like a copy of the baseline and is able to make notes on what are musts, shoulds, and best practices. That would be immensely helpful. And we can, like, if we can get those to me like the Monday before the meeting, I can look through and see where are the biggest areas of disagreement for us to target discussion. So if that's possible, great. I also understand y'all are very, very, very busy people. And that might be asking a lot. So, okay.
Kevin, can you remind me when the next meeting is?
It should be 2 weeks from today. I actually don't have Outlook open in this.
2 weeks. So I've got my calendar up. So 1 week, 2 weeks
Pulling it up
is
on my phone. It's not on the
No, it's
20th.
the 27th.
yeah,
We're waiting 3 weeks. Oh, well,
which
even
is
better.
better
We can-
for me because
Yeah.
I'm
Well, I think that's what happened is we all agreed that the 20th was not a good week. So.
Hot damn, I might have a chance of actually getting it done this time.
All right. Thank you, everybody. I very, very much appreciate all of your work as always. And I look forward to seeing you in 3 weeks. Have a
thanks
great,
everybody. Take care.
fun summer, August.
Oh, bye.